During the course of your civil lawsuit, what gives the defense the right to hire a doctor to have you examined to determine what the extent of your injuries are? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now, let's say you suffered a significant injury as a result of a careless driver, or maybe a doctor violated the basic standards of medical care, and you choose to bring a lawsuit in New York seeking compensation for all the injuries and all the harms that you suffered. And now, during the course of your lawsuit, your attorney notifies you that the defense, the people you have sued, now have designated a doctor to have you examined. Now, why would they do that? Well, there's a key reason for that. Anytime you bring a lawsuit claiming that somebody was careless or negligent, and now you suffered injury because of that, you now put your physical condition into issue. Now, what does that mean? It means if you're really claiming you suffered physical injury, now the defense has an opportunity to say, okay, prove it. Well, part of the way we prove it is by sending the defense your medical records, the doctors who you are treating with. The defense will turn around and say, listen, we know your doctors are sympathetic. We want to get our own doctor to evaluate the true extent of your injuries. And you know what the defense calls this? They call it an independent medical exam. Well, I will share something with you. There is nothing independent about this medical exam. They have doctors on retainer, the insurance companies and the defense attorneys, and now they will hire a doctor to go ahead and set up an appointment with you. So now you have to go in and spend a few minutes having the doctor examine you. When the defense doctor actually examines you, they are doing it for one reason only. They are not doing it to treat you for the purposes of treating your condition. They're not doing it to make you get better. They're only doing it to assess whether or not your injuries are truly as bad as you claim them to be. And here's the remarkable thing. The entire goal, the entire agenda for the defense doctor who is examining you is to try and disprove every part of your injury. That's their entire goal. To see whether or not you have a significant injury in a certain part of your body. To see whether or not you are truly disabled. To see whether you have restrictions of motion. Their job, their entire job, is to disprove every single part of the claim that you are bringing, claiming ultimately, hey, your injuries really are not as bad as you claim them to be. But because you now put your physical condition into issue by bringing a lawsuit, the defense legally has the opportunity to go ahead and have you examined by a doctor of their choosing. So why do I share this great information with you? I share it with you to give you a sense and an understanding of what happens in these civil lawsuits involving an accident case or a medical malpractice case. You know, I realize you're watching this because you've got questions or concerns about your own particular matter. Well, if your matter happened here in New York and you're contemplating bringing a lawsuit, what I encourage you to do if you've got questions, pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.